Welcome everyone. Hello, my name is Dayna Wilson, and I am excited that you're attending my first speaker studio session of the year. I'm the founder and the host of the series, and again, Dayna Wilson with Keller Williams Realty East Bay. And for those of you attending today that don't know me, I'm just going to share a little bit about myself. I earned the Series 7 and 63 securities licenses some years back and have been a licensed California Realtor since 2006. I hold the Seniors Real Estate Specialist designation, and I also help to spearhead the Luxury International Division in our Walnut Creek Keller Williams office. And we offer a very extensive boutique experience with global reach. So as a local real estate expert here in the San Francisco East Bay, I think one of the most valuable things that I can offer my clients in the community, aside from assisting with your home purchases and sales and investments, is to be a resource of information and education on all things real estate related. And I realized that this topic of Proposition 19 was going to be a hot one when the calls and the emails started flooding in. And it was soon after the New Year's, people wanting to know how the new law would impact them in their financial and real estate planning for 2021. So I really saw the need to bring you this webinar today, and I invited one of my favorite local attorneys, R.Silverman, to join me. So hi, Rob, thanks for being here today. And we will turn the time over to him in a minute. A little housekeeping before we talk real quickly about the market, the trends from last year and what we're expecting to see this coming year. You have an ability, we're going to try to keep this to an hour, but we may run over depending on how many questions we have. You'll have the ability to type in your questions down below. If you hover over the Q&A, you'll be able to type some questions in, and we will get to those at the end. We're going to have an encore presentation of this next Wednesday evening. We're planning on 5:30. If you have a friend that missed this today and you think they would find benefit in the information, they can register and join us next week. And we're going to be sending out in a follow-up email to all the attendees all of our contact information. So feel free to reach out to Rob or I if you need a consultation, if you want to really dig deep into your specific needs. You want a market value on your property before you get it ready for sale, whatever you need, reach out to us. We are here. All righty, so we're gonna do a quick review of the real estate market here in Contra Costa County, and then we're gonna jump into how Proposition 19 affects taxes and who will be affected, what will change and when, because after all, you'll need to look at both aspects of the real estate market and the new laws to determine what those right choices will be for you moving forward. So looking back, before COVID-19, do you remember those days? Before COVID-19, in the first few months of 2020, the housing market appeared to be on a very powerful upswing. It was hot. And then, of course, it took a sharp dive. The fear of the virus froze us, while our survival skills to collect extra toilet paper really jumped in and took hold of us. Lots of us became very good at hoarding. Real estate, though, thank goodness, was deemed an essential business, but realtors like myself had to pivot very quickly, almost overnight. But thank gosh, as life continues to happen and people need to adjust their housing, we're able to help them do so, even during this very trying time. So the 2020 housing market actually ended the year as one of the highest performing sectors in the United States economy. My crystal ball broke last spring and I haven't had the chance to replace it. But I do have a few predictions I'm going to share with you. And these include the following. The outlook for low mortgage rates should continue. They're expected to remain low through this year. In fact, recently I saw that the 30-year fixed mortgage, 30-year rate was right around mid-twos. Again, it hit another historic 60-year low. I think we'll see more home sales than in any year since 2006 in 2021. And in 2021, the number of Americans moving across county lines will surpass 14 million as people are searching for that home gym. They're searching for a home office. They're searching for more space for potential, learning, distance learning, as well as more indoor, outdoor living area. So what's interesting is that 14 million is 25%, an increase of 25% over the last couple of years. That's a lot of people. And this is really interesting to me that in the spring of last year, when we had to go virtual, when we started offering virtual tours, 3D walkthroughs, room measurements, virtual open houses, 45% of buyers made an offer on a home sight unseen. Would you do that? I don't know if I would do that, but 45% of buyers did. So lastly, I think we'll see more homes for sale as mortgage forbearances continue to increase. Our neighbors are finally ready and willing to list their homes, take advantage of what Prop 19 has to offer, and take advantage of the very high prices. So market trends are so micro-specific. I was going to show all these graphs and charts and talk about the market, and no, it's so specific that your neighborhood and my neighborhood is different, and even different price ranges are impacted. So for instance, everyone's average prices were up last year, with the exception of Blackhawk. So, and then it depends if it's single family or townhome or condo. So I'm not even going to get into the nitty gritty of it, but this is a perfect segue to turning the time over to Rob so he can jump into the presentation and teach us a little bit more about Prop 19 and how it's going to impact all of us potentially if certain things are going on in your life that you need to know as far as making a move or inheriting property or other things. So Rob, take it away.
Thank you, Dayna, very much. Appreciate your inviting me to speak. And I see when scrolling through the huge number of attendees today, I see lots and lots of my clients, names that I, folks who I've worked with for some, in many cases, many years. And in fact, interestingly enough, there are several people who are attending today who I'm currently helping with specific Prop 19 issues. Anyway, welcome. If I don't know you, if you're Dayna's client or otherwise, welcome and nice to virtually meet you. A little bit about me, I've been practicing law for a little over 27 years. I happen to delve into a number of real estate transactions here and there, even though my primary area is trust and estates. I do estate planning, trust administration, and probate. Those are my core areas, but real estate is certainly a part of estate planning, and it's sort of a subspecialty of mine. I happen to have been, like Dayna, a licensee. I've been a licensed real estate broker in California for 40 years. So I know quite a bit about real estate. And so Prop 19 is sort of a perfect, kind of combination of real estate, tax, and estate planning. And so I'm happy to present. There are a lot of ramifications, a lot of circumstances like Dayna's very micro planning, meaning everybody's situation is different. Same with Prop 19. There are very few sort of set answers here. But what I'm going to do is I'm going to go through the rules in as clear and simple way as I can and try to leave a fair amount of time open for Q&A at the end, because I know that there'll be a lot of questions. And of course, some of the questions will be such that it would take a half an hour to really discuss and dissect and answer properly. But we'll do the best we can to cover the complex subject area. So I'm going to try to share my screen here. And hopefully this works. Let's see. Okay, and let me get the full screen on here. So hopefully, Dayna, can you see that?
That's perfect. Yes, great.
Okay, terrific. So this is just the lead slide, and I guess really the first thing I should say is to not only again thank Dayna for inviting me to speak on this topic, but to compliment Dayna. I've known Dayna for a lot of years. She's a superb realtor. She's very client oriented, wants to do the right thing, of course, at all times, and she's extremely knowledgeable about estate planning and a lot of areas that are tangential to real estate, which just speaks to her professionalism. So I encourage you to speak with Dayna after this meeting if you have any potential kind of real estate transactions or questions about real estate planning. I highly recommend Dayna, and I would do so independently of this presentation. So moving on to California Prop 19 rules and ramifications. The first is a disclaimer. I'm not giving you legal advice. Lawyers love disclaimers. And so I'm giving you information of a general nature. Don't rely on it. If you're going to engage in any transactions, of course, you want to make sure that you talk to your own legal and or tax advisors. I'm happy to help independently of this presentation if you are interested, but this presentation is of a general nature. Okay, so what are the features of Prop 19? So there's sort of two main prongs of Prop 19. The first being that it terminates or severely restricts the current rules that enable many transfers of real estate between parents and children to be excluded from property tax reassessment. That is the prong that I'm going to concentrate on. There's plenty to talk about with that prong. But I would be remiss if I didn't at least introduce the second prong. And this is going to be more in the realm of planning to sell and purchase replacement residences. This is more in Dayna's realm. And that is the expansion of the current rules that enable those 55 and older and severely disabled persons to sell their California principal residence and replace it with another California residence without triggering a property tax reassessment. Basically, it used to be a one-time deal, and now you can do it up to 3 times. There used to be participating counties, and now you can do it anywhere in California. And you can actually get a blended benefit. It used to be you had to buy down in price in order to benefit, and now you can purchase up and still benefit. And if you purchase at a replacement, if the replacement property is more expensive than the relinquished property, you can still benefit, but you get a blend of rates. You keep your old property tax to a certain extent, and you have a new assessment for the portion that is above and beyond in excess of the old of the replacement of the relinquished property. So again, There's some particularities and details of those rules, but I'm just introducing that in general. The focus of my discussion is going to be on prong one, the termination or restriction of the current rules on parent-to-child transfers. So let's start out with there's a further distinction between principal residences and non-principal residences in terms of the current rules. So I'm going to go over the current rules, and then I'm going to go over the new rules, and then I'm going to go over what the ramifications of these changes are. So first, the current rule is that you can transfer a principal residence between parent and child, and it doesn't matter how much the value of the property is. If it's your principal residence and it's a transfer between parent and child, it doesn't matter if the property is worth $200,000 or $20 million. The transferor, typically the parent, but not always, can transfer to the transferee, for example, the child, regardless of the price. And under Prop 13, lots of people who bought many, many years ago, they have very low property tax assessment, and they can make a transfer without triggering a reassessment. And again, this is assuming certain forms are properly and timely filed. So I've given an example here. Parent purchased a home for $100,000 decades ago and still lives there. The home is now valued at $2 million. The assessed value of the property is $400,000 and under Prop 13, and property taxes are about $5,000 a year. The parent gifts the home to daughter and reassessment is excluded. So the same $5,000 a year property taxes is paid by the daughter as was paid by the parent. However, I put in italics here, if the parent happened to sell to a third-party buyer, then the property would be reassessed, and that reassessment would be based on the $2 million value of the current value of the property, and annual property taxes would be more than $20,000 a year. So as you can see, the current benefit of this unlimited parent-to-child or child-to-parent exclusion from reassessment can be enormous, particularly for folks who've owned their property a long time and had these very low assessed values on their property. Okay, so that's the status of the current rule on principal residence transfers. Now we're going to go into the non-principal residence transfers. There is a parent-child reassessment exclusion. However, it's limited for non-principal residences to an aggregate of $1 million of assessed value. And again, it's regardless of the fair market value at the time of the transfer. When I say the aggregate of 1 million of assessed value, what am I talking about? Again, I think that the example is going to be helpful. The parent purchased a condominium rental and a small office building many years ago. The condo is now worth $800,000, but it has an assessed value of $300,000. The office building has a current value of $1.5 million with an assessed value of $600,000. The parent gifts the condo and the office building to the parent's son. Since the aggregate assessed value, we've got an assessed value for the condo at $300,000. We've got an assessed value of the office building at $600,000. So that's an aggregate $900,000 of assessed value. And since that total is under $1 million, that's the limit of what you can do, gift or transfer for non-principal residence properties. The entire gift of those two properties is excluded from reassessment. And again, the parenthetical here is if instead of transferring it to a child, the parent sold these properties to some third party, the third party would be reassessed at an aggregate of $2.3 million because the aggregate value is $1.5 million plus let's see, $1.5 million plus $800,000. So you have 2.3 million of current value. And if anybody else purchased the property, it was transferred to somebody else, then all of a sudden it would be $2.3 million, and assessed value is just a little bit over 1%. Plus there's some other various charges for, sewer and other kinds of things, but generally it's roughly 1%. So that means an assessed value of 900,000 would translate into about a little over $9,000 a year. And the child, the son, would be getting the benefit of taking over these properties, owning these properties at about $9,000 per year in property taxes. Whereas if it was transferred by sale, or if these rules didn't apply, the property taxes would be a little over $23,000 a year. So a huge difference. So you can see from the principal residence rules that are currently in place and the non-principal residence rules, there's a tremendous benefit in making parent to child or child to parent transfers. Okay, now we're going to move on and we're going to contrast these present rules with what the new rules are under Prop 19. We're going to start with the new rule on parent to child transfers of principal residences. Again, you'll recall there's an unlimited amount that can be transferred under the current rules, but as of February 16, 2021, that's the date the rules become effective. The only way that you can get an exclusion of a principal residence is one, if only if the transferee, that is, let's say, for example, the child, moves into the home and makes it his or her principal residence within 1 year of the transfer. And even if that is satisfied, the reassessment exclusion is limited to $1 million of assessed value. We know what the value and property values around the Bay Area, that's going to be a big deal. The fact that for properties worth $2 or $3 million, and there's only 1 million of assessed value that can be protected and excluded from transfer, again, it's watering down and highly restricting the rule. Let's talk more about A, because this tends to be the bigger deal. Regardless of what the value of the property is, a huge number of clients that I work with, they make transfers upon death. They have in their living trust that their property will go to their child or children upon their death. And so if it's a married couple on the death of the last spouse, then a child or the children receive the property, and their decision to keep the property or sell it is largely based on how much they can earn when they rent it out. They have their own homes that they live in. They're not going to make it their principal residence. Some will, but many won't. Well, now, if that's the case for inherited properties after February 16th, then those folks will need to factor in a likely much higher property tax bill. And that could be the difference between whether the cash flow when it's rented out is appealing enough to even keep the property. So what's the long and short of it, what's going to happen is for folks who inherit property after February 16th, there's going to be no protection except for this limited principal residence protection. If a child or the children are going to be willing to make it their own principal residence within 1 year, fine. And again, it's going to be only limited to 1 million of assessed value. So pretty watered down, and it's going to make a big difference, huge difference for principal residence transfers after February 16th. Down here, I say if the assessed value exceeds $1 million, then it's basically a pro rata deal. The portion up to 1 million of assessed value stays the same, okay? That assessed value stays the same, and it's not reassessed, but the portion above the $1 million is reassessed. So it's basically a blend of reassessment exclusion and non-exclusion. So there'll be some benefit, but it'll be limited. All right, so let's go on to non-principal residence transfers. So this is very simple. After February 16th, there is no reassessment exclusion whatsoever for people who are transferring parents to children, children to parents. For if it's non-principal residence property, there is no reassessment exclusion whatsoever. It goes away. So every penny, every property that is transferred that is not a principal residence and therefore doesn't go under the rules we just talked about previously, there's going to be no reassessment exclusion. So once again, what's going to happen is a lot of folks who inherit non-principal residence properties are going to sell rather than keep it, because the reassessment is going to cause such an increase in property taxes that it's going to affect their cash flow negatively. And based on the reduction of that return, a lot of folks are going to just say, hey, look, I can't make enough money to be a decent return on investment by keeping this property because of the increase in property taxes. So instead, I'm just going to sell it.
Rob?
Yes.
I know questions are later, but I'm going to get this question. So the person would, they haven't passed yet then, let's say, right now. Is the February 16th, is that the after death, or is that the home has to have been sold by? So just want a clarification on that.
It's the transfer date. Has no, it doesn't make a difference whether the transfer is on death or well, let me back up. It's the transfer date. If somebody dies and their trust says that if somebody dies before February 16th or before February 16th, then that even if the trust hasn't been administered and the transfer hasn't taken place, that should still be a qualifying, she'll be qualifying under the present rules, because the quote transfer on a like a living trust or a probate would be the date of death.
Thank you. Thank you, because I don't know if the general public,
yeah, that's actually an interesting little technicality, right?
Thank you. Well, that's a big deal, though. People are going to start calling me saying, when do I need to list my home? Or when do I need to list the property?
Right. But that's only a factor on death. If it's a transfer between parent and child, it's when the property is actually transferred, recorded. The deed is recorded. Okay, so now we're going to go on and talk about the ramifications. The first is, many people have an instinct. They hear these, hey, there's new rules and we've got to act now, and they rush to say, hey, I'm gonna gift or sell, or partially gift and partially sell to my child or children. And I say, that's fine, that's an instinct. But then number two here is, before deciding whether or not to make any current transfer by gift or sale, or you can do a hybrid, careful analysis with the help of legal and tax advisors is extremely important. And you'll see when I get to the next slide and we start to get into this, why it's not just, hey, these new rules are beneficial, or the existing rules are beneficial, so we've got to jump to make these transfers. Well, there's a lot more to it than that, and we're going to get into what those things are now. So I've got just a list. There might be more variables and factors, but in deciding whether or not to make any gifts or transfers before the new rules restrict or eliminate property tax reassessment exclusion, consider these among other factors, okay? One is the difference between current assessed value and current fair market value. Maybe there is not that much difference. So you rush to say, well, I want to make sure this gets property gets transferred to my child so that I can get the exclusion. Well, let's suppose that the property is assessed at $500,000 and the fair market value is $600,000. So that's going to be, if there's a later transfer, the difference, assuming that value stays roughly the same, that's going to be the difference of maybe $1,000 a year in property tax. So if the property is kept over 10 or 20 years, that's $10,000 to $20,000. You better look at a lot more factors before you rush to do that. So the larger the discrepancy between the assessed value and the current value, the more impetus there would be to transfer before February 16th. So that has to be, that's one of the factors that needs to be looked at. Another is the total net worth of the transferor. So lots of people are very generous with their children, and I applaud that, but we've got, let me give you a hypothetical. We have somebody who is a parent who is 65 years old or 70 years old. Their life expectancy might be another 15, 20 years or so. They have a property with equity of $1 million and their total net worth is $1.5 million. Should they rush to make this transfer? Probably not, because they're giving up $1 million. Now they might say, oh, well, my kid will take care of me if I make this transfer, but I want to get this benefit. Well, let's suppose they might live for another 20 or 25 or 30 years, right? So, you know, non-trust, real estate, you know, related, but other financial factors should play into whether or not somebody wants to make the transfer. Alternatively, let's say that the property is worth $1 million and the parent has another $19 million in assets. Well, then the parent's not going to worry about making that having that transfer cause a problem with number 4 here, which is the potential for the gift of transfer to compromise the transferor's future lifestyle. Forget about all the tax stuff. Is the transfer, or might the transfer compromise the transferor, parent, typically, lifestyle? If so, I don't care what the reassessment exclusion is. It's probably not a good idea to make that transfer. Let the chips fall as they may with some future transfer upon death. Here, the percentage of the value of the property being gifted to the total net worth of the transferor. So again, just another way of looking at the economics. If the percentage of the value, you know, if the property being gifted is, as I used the hypothetical before, $1 million property and $1.5 million total net worth, if the property is that high a percentage of the total net worth, then again, it has the potential, all these sort of come together in, is it going to, or might it affect a transfer affect the transferor's future lifestyle? Okay, what about the transferee? The parent might say, hey, I want to make this transfer to take advantage of these rules. But what if the transferee child, for example, is a gambling addict or is very young and irresponsible? Regardless of the reassessment exclusion that's available under the current rules, is it a smart idea to make a transfer to a child who just may completely flake out, may get the property foreclosed because they don't make the mortgage payments or whatever? So that, of course, should be a factor. This is something that a lot of people don't think much about, but once somebody makes a transfer, let's suppose it is a principal residence. And let's suppose that the transferee, the parent, wants to stay in the property. They want to make the transfer. Gee, I want to transfer it to my daughter, Betty. Okay, it's because I want to take advantage of this unlimited principal residence exclusion. Fine. Once Betty owns it, then is it going to be a deal where the parent lives there rent-free? Maybe. Okay. But Betty's going to own it. Betty gets into an argument with the parent, and or Betty has some financial circumstances. Betty could sell that property out from under the parent that's living there still. Betty could, charge, say, you're welcome to stay there, but you need to pay rent. I own the property now. Parent, sorry, you need to pay rent if you want to stay there. Of course, these things can be worked out in some kind of agreement, a gift agreement, where it's being gifted, but the parent reserves the right to stay there rent-free over a certain period of time. There can be any kind of a contract developed, but rent could be an issue. Let's suppose it's not a principal residence and it is a rental property. Well, the parent wants to take advantage of this up to $1 million of assessed value for non-principal residences. So they want to transfer to a child or children. But wait a minute, the parent partially depends on or enjoys the net income from this property. Once the property is transferred, then the income goes to the transferee. The income is going to belong to the children. So if that's thought through, some parents are going to say, look, I'd love to take advantage of these rules, but I don't want to lose out on the income. And so I'm not going to make the transfer because of that. There are other ways to slice and dice this. So you can have your cake and eat it too, potentially, if the parent trusts that the child will gift each year the income from the property. Fine, but again, that either has to come out in some sort of a contract or a huge level of trust and circumstances not changing, so that the parent can rely that the child will get this nice benefit of the reassessment exclusion under the current rules. But the quid pro quo, really, the understanding is that child is going to take this $10,000 or $15,000 a year or whatever the net income is, and is going to gift that back to the parent each year. So there are ways to deal with this, but the main point here is that it should not be forgotten that once a transfer is made between parent and child, any rent, either payable by the parent who's still living there or rent that comes in from tenants on an income property, is going to belong on the surface, unless something is transacted and an agreement to the contrary, the rent will belong to the transferee, typically child. So this just needs to be considered. This Roman numeral 7 is very important. How long is the transferee likely to keep the property? The big benefit of property tax reassessment exclusion is if the child or if the transferee is going to keep the property for a long time. If the likelihood is that the child is going to sell the property within a year or 3 years or 5 years, and that's pretty darn certain, then the actual economic benefit of this reassessment exclusion is pretty minimal. And so it's likely that if you really run the numbers and you say, well, the benefit of a 3 or a 5 year holding period might be $3,000 to $5,000. Am I going to go through and typically pay an attorney to do the transfer paperwork and relinquish all my rights to and economic interest in this property just so the child can potentially get a few years of property tax benefit? That doesn't make a lot of sense. So the how long the transferee is likely to keep the property is important to look at. Of all these factors, in many ways, the last one is the most important, and it may be the most important by far. So this is lost on a lot of folks. I'm going to go through it fairly quickly so that we have time for a lot of time for Q&A. People concentrate on this Prop 19 and gee, I got to jump to transfer the property because to allow my child to take over this low property taxes that I'm paying, but they forget about the income tax factor. So what am I talking about here? Very simply, and this is a little bit complicated, but I'm trying to do it very simply. Under today's income tax law, when somebody inherits a property, they take over on what's called a stepped up income tax basis. So let me give you an example. Somebody owns a property that they bought at $100,000. So that's the income tax basis. They never made any improvements to the property, but they bought it at $100,000 and it's worth $1 million. Okay. And let's suppose the parent is 90 years old. If the parent transfers the property by gift, let's say now, okay, and the child gets these property tax benefits. Well, if that doesn't happen, let's say the child inherits the property. The parent is 90, and within 5 years, the parent dies, and through the parent's trust, the child inherits the property. And the property value at the date of death of the parent is $1 million. The $100,000 income tax basis, which is the floor from which capital gains get calculated, steps up to the fair market value on the date of the parent's death. So on the parent's death at 95 years old, that goes up to $1 million. If then the child sells the property, they're going to sell it at $1 million because that's the value. They're going to have an income tax basis at $1 million. And they have no capital gains tax. Contrast that with when somebody transfers it during life. So the 90-year-old parent instead transfers it to take advantage of Prop 19. And there's an income tax basis of $100,000. That income tax basis of $100,000 does what we call in this, the technical term is carries over. It's a carryover basis. So the child, upon the transfer, receives a $100,000 income tax basis. So when the child sells it 5 years from now, let's say at $1 million, the child is going to have to pay capital gains tax on the difference between the $1 million sales price and the $100,000 tax income tax basis. So the child won the battle, which is the property tax battle, and they lost the war very, very badly because they ended up paying hundreds of thousands of dollars on income tax, capital gains tax, that they would not have paid had they inherited the property on the parent's death. So the age of the transferee, if it's very elderly folks who are looking into making a transfer, and they're very close, I mean, life expectancy isn't a huge number of years, then you've got to look at that. If the child may well sell the property after the transfer, then the potential income tax savings on inheriting it instead of receiving it by gift now may outweigh the property tax benefits to the tune of 50 times. So a careful analysis needs to be done in terms of what's the income tax basis and how likely the child is to sell the property. Just before this morning, I was talking to a gentleman who was looking to transfer a legacy property, a Tahoe property, to children. Now, income tax, and I wanted to make sure they understood what the income tax ramifications were. They understood this step up in income tax basis issue, but income tax only gets triggered upon a sale. And the kids were going to keep this for decades. It was a legacy Tahoe property. It was going to be kept for decades. And therefore, yeah, I understand the potential disadvantage of not inheriting it at a step up in income tax basis, but it's not an issue because I'm 99.9% sure that the kids are not going to sell the property. They're going to keep it until they die, and then it's going to go to the grandchildren. And so I'm not worried about the income tax ramifications because it's a legacy property and it's going to be a long-term hold. Fine, but you better look at it carefully, because lots of times my experience is in helping people administer trust and so forth, that what is anticipated to be a hold on the part of the children, sometimes the parents really want that because there's some emotional attachment to the property, but very often, even when the kids intend to keep the property, they don't end up keeping it. It just doesn't pencil out. They don't want the management headaches, and they end up selling the property. And so the fact that they might sell it at some point after it's transferred means that you really need to look at what the potential income tax, capital gains tax detriment is going to be to the child versus the current property tax benefit to the child in making the transfer. So this is a really important thing. But all of these, and there's some others, but I just put together a list of sort of the bigger ones that I could think of, but there's lots of factors, and that will end up resulting in, gee, somebody has a consultation, and at the end of the consultation, they say, you know what, I'm not going to make the transfer. Okay, so in wrapping up here, weigh the factors carefully and pay particular attention to how much, income tax detriment we were just talking about versus property tax. And be mindful not to let the, quote, tax tail wag the dog. There's lots of other things. There's personal, feelings about making the transfer or not making a transfer. And sometimes those outweigh whatever tax benefits may or may not accrue. So this is just sort of a saying that we legal and tax professionals use sometimes to say, yeah, tax is important. Everybody wants to pay attention and know what the tax ramifications and consequences are for a particular transaction. But that's not all that's going on here. Look at everything. So I hope I was reasonably clear, and I hope you learned something significant. Once again, thank you for Dayna. I'm going to turn it over to Dayna now, and Dayna can start to field some questions and or make other comments.
Excellent, excellent. Rob, that was awesome. And I think people got a very clear understanding that it is not as simple as what we thought we voted on in November. We only think we're voting on what the TV ads are telling us it's all about. And, they don't go into this kind of a detail. So if you want to unshare your screen, then there you are. So we do have a number of questions. We're going to try to dig into those. I had a couple of people actually emailing me questions prior. Okay. And one woman would like to know the pros and the cons, Rob, if she adds her daughter's name to the title of her primary home before Prop 19 or after Prop 19.
So it's a great question. Unfortunately, it's way too complicated because of all those factors that I just talked about. It's sort of impossible to answer that in a vacuum. I wish I could, but again, I would in response to that question, I would have a whole bunch of questions. How old is this woman? What are the circumstances? What's the current assessed value? What's the current full value? And lots and lots of other questions in order to really analyze whether it's worthwhile. But it does bring into focus something that's important. Here we're talking about maybe some sort of a blend. In other words, adding somebody to the title isn't a transfer of the entire interest. So the exclusion rules would still apply to whatever portion was transferred. So if by quote adding, somebody brings on as a 50% co-owner their child, then that 50% that's transferred to the child is still, it doesn't have to be, it's not an all or none deal. It doesn't have to be 100% transfer to be, to enable these existing rules. They can apply to a 50% transfer, but once again, somebody says, gee, this is the nice thing to do. And a lot of people try to do this for convenience for estate planning purposes. And it's usually for the income tax reason I talked about, a really bad idea. People say, I don't need a living trust. I'm just going to add my child as a joint tenant. I'm just going to add them. Well, all of a sudden, I'm getting older, and I know joint tenancy, as you know, Dayna, and many people know, joint tenancy comes with a right of survivorship. So on one joint tenant's death, let's say the parent, the surviving joint tenant owns their interest. Easy. You don't need to worry about probate. You don't need to worry. But we have that income tax problem that is huge. So yeah, they solved the problem of probate avoidance, and they thought that was a clever shortcut, but it turned out to be a really bad idea because of the income tax situation. So I would caution anybody who, and I unfortunately over the years have gotten consultations by people who said, I already did it. I added them to the title. And then I have to be the bearer of bad news. You really should have gotten some advice, because that was a really bad idea. And let's see if we can maybe undo it or whatever. So just the whole nature of the beast of adding somebody to the title, huge red flags. It may be perfectly fine, but you should really get good consultation before you add anybody to the title.
Yes, and I more often than not, in my personal experience, it was not really what the parent intended to have happen in the end. They didn't understand the situation clearly. All right, so we have lots of questions. Let's see. How about someone who used their previous one-time relocation and transferred their tax basis? Now with Prop 19, do you start at zero again? do they have 3 more times?
That's actually a great question.
That is.
One of the traits of an experienced professional is to say, I don't know when you don't know. Okay, so I'm going to say, I don't know. That's a really interesting technical question, and partially because I've paid much more attention in my practice to the first prong, which is reassessment exclusions between parent and child. I have not paid as much attention. I know the rules in general, but it's a good question, but it's very technical, and I just don't know the answer to it. It'd have to be looked at.
We'll have to find out. I could guess, but I'm not going to guess. And by the way,
right.
I am not licensed to give tax, legal, or financial advice, and I don't believe Rob is licensed to give tax advice per se. However, between the two of us, we have quite a lot of very wonderful local experts, seasoned advisors. We'd be happy to refer you to people if you need a good CPA or such. Is that all right?
Yes, and Dayna, if anybody wants to email you or me or
yes.
both of us,
yes,
like that type of question, hey, Rob, you or Dayna, you punted on that question during the presentation. Is there any way you can give me an answer? I'd be happy to look that up for, and maybe you could too. But that's a sort of a pretty simple, straightforward thing. And of course, I'm not going to put anybody on my clock to do something quick and simple like that. So feel free to email questions that we don't answer. Yeah.
Great. What are the federal income tax consequences to parent and child of transfer of ownership to child?
So to recap very briefly, the consequences are that there's a carryover in income tax basis. You need to check with your accountant to know what the income tax basis is on the property that we're talking about. And a carryover basis means the transferee, and again, usually child, takes over the same income tax basis as the transferor had, which means that on a future sale by the transferee, there's going to be some kind of income tax consequence. And alternatively, if there isn't a lifetime transfer, but instead there's a transfer on death through a will or a trust, then there's under current law, there's a step up in income tax basis, so that the new income tax basis on somebody's death is the fair market value on the date of death. That's the floor from which capital gains gets calculated. So these things need to be looked at. I hate to even say this, but I'm going to complicate things. But stay tuned. Now that we have a Congress that's controlled by the Democrats and a Democratic president, the platform is such that at least it's on the table in the future for possibly eliminating this step up in income tax basis on death. So stay tuned. That's not, there's no guarantee that's going to continue to be the rule.
The story is not over. All right. Okay, well, let's see here. And I think we've already answered this. What happens if the principal house is titled into a trust and the heir is part of said trust?
It's fine. The trust is, it's a see-through situation. So whether it's a transfer via, I'm not sure this is what they're asking, but if two children receive a home through a trust on a parent's death, okay, they're going to be entitled to the same rules as if they just got a transfer. In other words, there's a see-through. It doesn't really matter that the transfer is through the vehicle of the trust. The property tax rules are going to stay the same.
Perfect. Okay. How long must the child live in a property to establish residence? And what if child eventually converts it to a rental?
Super good question. The answer is, I don't know. There are a lot of, this is a perfect example of the kind of very technical permutations and combinations and things that could happen that aren't necessarily clarified at this point. There will be undoubtedly more rules promulgated to clarify just this kind of thing. So I don't think there's anything in the current statute that addresses that, to my knowledge. So we have to say on that type of thing, stay tuned. That is going to be important because people are going to try to do all sorts of clever things. Well, fine, okay, I'll move in. I'm a child and I'm going to move in and make it my principal residence within a year. And then I'm going to stay there 5 minutes. And then I'm going to move out, right?
I wonder if they'd ever use, do you think they'd ever use like, you know, in my securities days, we worked with a lot of people utilizing the IRS 1031. And there was no bright line on that. So some people said, well, we want 2 years, or we might, if you have a more of aggressive CPA, we might be okay with a full tax year. So I don't know.
It may well come to that. There may not be a bright line, and then it's a matter of, gee, are you going to take a chance? Are you risk averse? Are you going to take a chance that it gets audited and maybe disallowed?
Yeah, I'm going to tee this next question up to you, and then I'm going to step away for one quick minute. If parent gifts to child, they won't be able to take advantage of cap gains step up. So why would you take advantage of the property tax rule only to create a capital gains tax? You just talked about that. So perfect.
I did.
Okay, you did.
Maybe there won't be any tax triggered because the recipient will keep it forever. So it's only triggered on a sale.
Yes.
Maybe it's not that much of a difference between the basis and the price. So yeah, there's no step up, but there's not that much of a distinction between the basis. So there won't be that much of a gain. So yes, I see the point, but it has to be looked at.
Yeah. And then for the first part of the new law, what date does this become effective? Will this generate a lot more selling by older residents?
I don't think it'll generate it because, first of all, the rules become effective February 16th. I do not think that this will generate a lot more sales by folks. It's basically too late to sell at this point, but we're only talking about parent to child transfers anyway. I think what it's going to do, it's going to generate a lot more sales by children who are receiving property after February 16 by gift or inheritance. It's going to trigger a lot more sales by the inheritors because of the because of the increase in property tax as a result of these new rules.
Now, I can get a home sold in 10 days. Why do you think it's too late to sell a house?
Well, I mean,
or 7?
It may not be, but if they're selling, the only reason to, I mean, if there's a reason to sell that has nothing to do with Prop 19, great.
Right.
They wouldn't be selling to take advantage of these rules unless they're selling to their children.
Right.
Right.
Okay. I had my property reassessed on death of first spouse. I'm over 90. Does the new assessment count for transfer?
So this is where terminology gets mixed up, and this is very common to get it mixed up. It did not get reassessed. That we think we're talking about property taxes. Okay, that is not what happened. On the death of it's a little complicated. On the death of one spouse in California, if the property was owned as community property, Californians get a bonus because we have a community property state, and there's a step up not only when one person dies, but when the first spouse dies. If it's community property, it gets a full step up. That's not I know it's terminology. That is a new income tax basis. That's not has nothing to do with property tax. Okay, that's a step up in income tax base, and that would then be factored into the decision. That's a good thing, and therefore it may not be as much of an issue at all to transfer to a child for Prop 19 purposes, because you've already gotten this recent step up when the first spouse died.
Yeah. All right. If someone sold their home last year, do they have to buy a new home before March 31st to carry the old assessment forward, or do they have 2 years?
Again, because my focus has been on prong one, I just haven't gotten into the weeds on that, but that would be a question to email Dayna or me or both of us. And I just have to look at those rules because I'm just not familiar off the top of my head for the rules on replacement and residences for those 55 and over.
Well, so I did read that you would transfer the taxable value of a primary residence anywhere in the state within 2 years of the sale of the original primary residence. But doesn't that have to take effect after April 1st?
Yeah, see, that's the detail that we need to be very careful with before.
Right.
Yeah.
Right. Okay. This is interesting. I've had someone else ask me this. Original writing of Proposition 19 and on the ballot said over 55 versus 55 and over, which is correct.
I love smart people who are who pay attention to the details.
They're actually reading it. Good grief.
That's right. I think it's 55 and over the way the current law reads, but again, these are the kinds of things where I don't make assumptions. I get into the books and I make sure before I comment. Before I want to take some more questions, but some people may be dropping off because of the time. I want to mention one other thing that's important that I haven't mentioned so far,
okay.
And that is when there's a transfer or a contemplated transfer to more than one child. Okay, or there's a transfer to one child of the property, but the parent or parents want all the children to be treated equally. I just got off the phone this morning and talked to somebody about this. they may want to say, there's $300,000 of equity on this property I'm transferring to my son, Joe, but my daughter, Jane, I want that benefit to go to Jane. It may well be you can still do this transaction, but then the parent who's making the transfer should amend the parent's living trust to put in an equalizing provision. That's fairly easy to do. It's fairly common. We do that all the time. So you can still treat everybody equally by transferring the property to one, but not all the children, but it usually requires an amendment to your living trust. So don't forget to do that if your goal is to equalize among children.
Interesting. Okay. Let's see. Gosh. Do these changes apply to grandchildren when the child has died?
There's a grandparent to grandchild exclusion, but in order to qualify for it, the parent in between the grandparent and the grandchild has to be deceased. So well, if everybody in the 3 generations are living and the grandparent wants to make a transfer to the grandchild, it is not going to qualify under these current rules.
But she's already said her child's passed away. So
if the child has passed away, and then if there's there may be it depends partially, I think, whether or not the second, this is very rare in applications, so again, I'd have to look at it, but it may depend on whether the other parent of the grandchild, the other parent of the grandchild is living as well. It may not. Again, this comes up pretty darn infrequently, so I don't know the technical aspects of the grandparent to grandchild transfer off the top of my head. That would have to be looked at, that to give very specific advice about that.
Okay, got a few more here. Is there a principal let's see, if there is a principal residence, a parent transfers upon death to a child post Prop 19, and the residence was acquired in a 1031 exchange, what are cap gains and prop taxes reassessment implications? Well, interesting.
Well, there's a whole bunch kind of intermingled there, but the regardless of exchanges, this, that, or the other thing,
yeah.
if we're talking about post Prop 19, if it's a principal residence of the transferor,
and it says principal,
and then upon before exchanges or when they bought or anything like that, starting February 16th, if it was the principal residence of the transferor, then it's going to qualify under the new rules for principal residences, which means the transferee child has to make it his or her own principal residence within 1 year, and that's limited the reassessment exclusion to $1 million. If it's a non-principal residence post Prop 19, post February 16th or after, then we already know from my presentation, there is no reassessment exclusion whatsoever, period. That's for property tax. She also weaved in the
cap gains.
Cap gains, and that has to do with step up in income tax basis if it's held on death. If it's that's an analysis, and talk to your CPA about what the income tax basis is upon the transfer. And the general rules are what I talked about, which is carryover basis, whatever that basis happens to be, it's going to carry over upon a lifetime transfer, and it's going to step up on a transfer on death.
But wouldn't the fact that they acquired something in a 1031 exchange, which means it had to have been a non-primary residence.
But then it could have been converted later.
And
from a
then they
non-
converted it later. So really the 1031 has nothing to do with this at this point. That would be
Correct.
my guess. I don't know. Don't know.
Yeah.
Okay, let's
Correct.
see. And I think you just answered this. If property is inherited by two children, does only one child need to establish? Does only one child need to establish residency? That's a really good question.
That is a good question as well. And if only one, let's say, I don't know for sure. My instinct tells me, but certainly don't rely on any of this stuff unless you do a consultation. But my instinct says that if not 100%, it would be at least 50% qualified. And it may not qualify, may or may not. I just don't know as to the 50% that belongs to the child who didn't make it their principal residence within a year. Great question, very technical, and I don't know the answer, but I would look it up if I needed to.
Really good questions. And I think we got through most of them. Some of them you already answered, and then some people said, never mind, he just answered my question. So that's just how thorough you are, Rob. So I am going to end this because we did go over, but we sort of warned you that we expected we might, because we had lots of really good questions. We'll get out our information, so you'll be able to contact us with any further questions or needs. Excuse me. If you are getting ready to move to a different area, county, state, or country, I'm happy to do my due diligence on your behalf and refer you to great agents in wherever you're moving. So I've got clients right now that are moving up to the foothills of California. Some are moving out of state, North Carolina. I mean, people are moving. I've got some people moving to Canada. So people are on the move for sure. So we're happy to do that. And then people keep asking, are we going to be recording this? We're going to rerun this next Wednesday evening. And if you send me your email, I'll make sure that you are sent the registration link. And I think that's it for now. So I think we better wrap this up so we can all get on with our day. But if you learn nothing else today, you realize that it's not as simple as we thought. And it does take a consultation with your trusted advisors to really understand the full picture and get all the right information before you make the right decision. So Rob, anything that you want to end with?
The only thing that I would say is, Dayna, thank you. I applaud you for putting this together. Getting information out to the community and to our, clients and colleagues and friends is terrific. So I applaud you. Thank you.
What we do. Well, and thank you. You're excellent at what you do too. And I highly recommend Rob. He's a great estate planning attorney. And I didn't know you were also a licensed realtor.
Yeah, it ages me, but I got my real estate license in 1979,
Nice.
and I got my broker's license in 1981. So all that says is that I'm an old guy. But
no, that's awesome. Well, I wish you well. I wish everybody on the call well. Thank you for joining in. Get in touch with us if you need anything further. And everyone have a great day until the next speakers studio, which actually is coming up later this month. So thank you so much. Bye. Bye, Rob.
Bye.